In foreclosure, the bank has to show it owns your house. But what most people don't know is that almost half the time, the banks don't have the paperwork to prove it in court. In many cases, it ends up lost or destroyed. It's a national problem the banks would love to keep quiet, because knowing that could be your best defense in fighting foreclosure.
Hi, this is Vince Khan. Thank you so much for downloading the Foreclosure Defense Guidebook. You'll see the link to download the book right down here below this video. But before we get started, I'm sure as you're coming to this site, you know somebody currently facing foreclosure, and you want to discover some strategies on how to slow or stop the foreclosure from happening, so that you have more time to figure options available to you. So I want to go through 3 surefire strategies that you can use to stop the sale, because at the end of the day, you want to stay in your home. I've got a much more detailed webinar at the end of this presentation that you can opt into, which will show you in great detail how the fraud is being perpetrated, and that's to show you that you have actually a lot more options than you think. So let's get started. There's a dirty little secret that the bank doesn't want you to know, and that is you have far more options than you think. Let me show you a quick video created by 60 Minutes that exposes what's going on in the loan industry that you probably aren't aware of.
For a lot of homeowners, it looks like it's not clear exactly who owns their home, right?
Who owns the mortgage? That's exactly right. When Wall Street was creating these exotic mortgage-backed securities, these were the things that blew up in the mid-2000s and sent nearly the entire world economy toward the Great Depression too. They were taking the mortgages of average folks, thousands of them at a time, bundling them all together in these securities that got sold from investor to investor. Well, what we're just discovering now is that when the banks crack open these investments, if you will, and look for the paperwork on who owns what, it's missing. So this has created a bit of a train wreck in courts all across the country, because they go in to foreclose on people and they can't figure out who truly owns the mortgage.
So what did the banks do, finding that these documents were missing?
At some of these companies, a decision was made to recreate the documents. So these document mills sprang up, like the company called Docs, D-O-C-X, that we found in Alpharetta, Georgia. And what Docs was doing was creating tens of thousands of these assignment of mortgage documents. Well, Docs was hiring high school kids who were signing these by the hundreds and hundreds and hundreds, as if they were bank vice presidents.
Forging them.
Forging the names of other people.
The name is Linda Green, but on thousands of mortgages, the style of Green's signature changed a lot. And even more remarkable, Linda Green was vice president of 20 banks, all at the same time.
Now, you did find someone named Chris Penley who worked in the same forged document mill that Linda Green worked in.
That's right.
Now, tell me about Chris Penley's job at this place.
Chris Penley's job was to sign documents, and he would sign whatever name needed to be signed at that moment in time. And there are 12 people around this table all signing these documents at the same time.
All signing Linda Green?
Many of them signing Linda Green.
So you're Linda Green?
Yes. Can't you tell?
Chris Penley told us that they had these documents stacked up like this on the floor all over the room.
How many of these documents would you sign, say, in a given day?
Averaged 4,000.
You yourself?
Yes.
How do you do that?
And after we did our interview, he pulled me aside and he said that one day when they were all signing these documents, he looked up to all the people around the table and said, "One of these days, we're going to be on 60 Minutes." And sure enough, here we are.
Now, just imagining this, and at times in watching your story, you don't know whether to laugh or just gasp in horror.
It's both of those things.
As demand exploded, Docs needed more Linda Greens.
The documents they're signing, those are people's homes.
These are the ownership documents underpinning the American dream. These are people who are about to lose their homes. Mm-hmm. The bank doesn't have the evidence to make that happen. So how do they solve it? Forged, phony documents.
At the core of this, fundamentally is a matter of what's called standing, and standing just means that who actually has the interest to foreclose on your house. Is it the servicer? Is it the original lender? Who actually owns your note? Nobody really knows, and the bank is basing their procedure based on your ignorance and lack of understanding, and it's done deliberately. The other thing that I want you to take a look at when you look at your deed of trust is this particular paragraph 24, which is called the substitution of trustee clause. And here you notice it says lender at its option may from time to time appoint a successor trustee. So I won't read the rest of it, but let me highlight the point here. It's the lender at its option, not the servicer, not anybody else, only the lender at its option from time to time. So in contract law, what it says is in the event of ambiguity, the interpretation is ruled against the drafter. So oftentimes these documents are drafted by your lender, and so therefore in the event of ambiguity, it's actually to your benefit. So in this case, you can actually bring this up to court as well as to the trustee, and I'll show you how to do that later, that the servicer does not have the right to appoint a successor trustee at all. In fact, they're actually breaking the law and clouding your title when they do that. So do you see what I'm saying? There's a lot more going on under the surface than you might realize. So fundamentally, like I said before, it's a matter of standing in which your lender, servicer, bank, pretender lender has to prove that they own your note before they're able to foreclose on your property. And oftentimes they're resorting to fabricating documents, committing tax fraud, committing notary fraud, committing a lot of things just to fabricate the documents that they need to steal your house. And what fundamentally happens is there's a lot of broken chains of title from A to Z, where your lender cannot prove the chain of assignment from the original creditor whom you took the loan from to the current owner, who we don't even know who that is. And there's no way for them to prove to you that they actually own the right to foreclose on your note. So the question that you want to ask is, who owns the note? Who has the right to actually foreclose? The answer lies in what's broken in your chain of title. So one of the ways that you can stop the sale is to notify the trustee. And when you discover the irregularities, as I will show you in the more in-depth webinar later on, is how to uncover the loan fraud, and then how to then notify the trustee of these irregularities. So the trustee operates under impunity, which means that they can do anything they want with the assumption that everything is smooth. When you notify the trustee, now they're personally liable for anything that they do, because when they operate under ignorance, then that's one thing. But once they are notified, then they are a cohort. In other words, they're collaborating with the crime perpetrated against you, and therefore they're actually liable to be sued if it is discovered that the procedures are operated under fraud. So one of the ways you can stop your foreclosure is to write a letter stating the irregularities that you discover. Like I said, I'll show you how to discover those irregularities in the webinar follow-up, and then you notify them in a formal letter through certified mail return receipt, notifying them and putting them on notice that they are committing fraud and they are to stop this. So you actually have the right to instruct the trustee to stop the sale because the transfer of the chain of title is irregular and they do not have the authority to do so. You can actually revoke their authority. So I hope that makes sense. So the second way you can stop the sale is file an answer if you are in what's called a judicial state. Most states, the eastern United States, are under what's called a judicial state, in which the lender has to file a lawsuit against you before they can actually repossess or foreclose on your property. And in this case, all you have to do is to file an answer challenging the standing. Again, I will show you how to discover the irregularities of the chain of title in the webinar coming up. And you challenge the standing to ask the lender who actually has the note, who actually owns the note, and the fact that they are not the right party of interest. Remember, in court, the plaintiff, the person doing the accusing, has the burden of proof. If your supposed lender or your servicer is filing a lawsuit against you, they actually bear the full burden of proof to the court to prove that they actually have an interest. If they do not have an interest or the right to foreclose, they don't have what's called subject matter jurisdiction, and therefore they're actually committing fraud in foreclosing on your house. So that's another remedy that you have available to you if you live in a judicial state. In a non-judicial state, the only option that you have available besides notifying the trustee is to file a lawsuit against your lender. And the idea is you have to uncover all the irregularities. Remember what I said before, the burden of proof is on the plaintiff. The person who is wronged, the person who is doing the accusing, has the burden of proof. So it's up to you to uncover the fraud and then put that as a legal defense and then file it into court to get a temporary restraining order. We have a process to show you how to do that exactly as well. So your job in fundamentally to how to stop the foreclosure is to gather all this evidence to expose the fraud against your lender. I hope that makes sense. Your job is to find all the irregularities in the deed of trust, in the assignment of the deed of trust. Again, all this will be explained in a lot more detail in the webinar coming up next. And once you file your lawsuit, one of the things that you can ask for in your lawsuit, if the evidence that you have compiled is compelling enough, is to request for what's called a TRO, or a temporary restraining order, or a temporary injunction against your foreclosing party. And the temporary restraining order will stop them from foreclosing on you indefinitely, or until the lawsuit is completed, or as the judge sees fit. So that's one way that you can use to stop the sale. So another way you can use to stop the sale is what's called a bankruptcy filing. When you file for bankruptcy, there's this thing called an automatic stay of sale in a bankruptcy, which means basically all the creditors are put on hold, put on notice to stop their collection. It's called an automatic stay. And what happens is once you file that, your lender cannot proceed with their foreclosure unless they get approval from the court. And so what they often do is file what's called a lift from automatic stay. And in our coaching program, we'll show you exactly how to object to that lift of automatic stay. In fact, there's quite a few number of successful lawsuits and case law, body of law that has been ruled on in the homeowner's favor simply on the matter of standing alone. In other words, the bank always has to prove that they are the right party of interest. And as you saw in the 60-minute report, that's oftentimes not the case. So I want to take a moment to just go through quickly the difference between a Chapter 7 and a Chapter 13 bankruptcy. A Chapter 7 simply gives you the right to surrender to your creditors and asking the court to give you a clean start, a clean slate, which means all your debt gets dismissed completely. There is a limitation on how you can qualify for Chapter 7. You have to pass what's called a standard means test, and it varies from state to state. It's best to consult with a bankruptcy attorney, or just go onto Google and search bankruptcy Chapter 7 income means test, and you'll find what those numbers are to qualify for a Chapter 7 in your state. Under Chapter 13, it's called a reorganization of debt, where you consolidate all the debt and you do sometimes what's called a cram down, where depending on how much money you make, you can actually get a discount on paying back how much is owed against the loans or your creditors. One of the advantages of going for Chapter 13 is that you have the ability to file a lawsuit in Chapter 13 called an adversary proceeding. And we'll go through a lot of that in the coaching that we'll provide later on as you follow this coaching program that I'm going to be teaching you. So under Chapter 13, what the requirement is, you actually have to have an income and you have to propose a repayment schedule so that it's workable and that the court will approve. So if you don't have an income, if you're currently unemployed, then unfortunately then Chapter 13 may not be available and you have to seek Chapter 7. Best thing to do if you're thinking about bankruptcy is to talk to a bankruptcy attorney to see what options are best for you. But in our experience, if you are facing foreclosure, your best bet in stopping a sale is bankruptcy. It's by far the best and most surest way to stop the sale. Obviously, bankruptcy is not something that you want to take on lightly. There is a lot of severe consequences under bankruptcy. One of those consequences is that any money you have, any savings that you have, has to be surrendered to the courts to be used to repay your creditors. So I hope that makes sense. But Chapter 13 does give you the right to sue your creditor under what's called an adversary proceeding and get a declaration if it can be proven that your creditor cannot provide proof that they are the right holder in due course, that they are entitled to enforce the note. And I want to keep you in mind that these are what's called temporary solutions because they are only there to temporarily stop the sale. We have a much more involved process right now, or you may not have the time right now to go through that in-depth analysis. I have a whole coaching program to teach you how and expose you all the fraud that's going on. But these are just temporary solutions that you can use to stop the sale. If you're interested in a more permanent solution, I actually have a full book that shows you, exposes you to the fraud and shows you exactly step by step on how to stop the fraud completely in this book called the Foreclosure Defense Guidebook. And you can download it at the link down below right here. The other thing I have for you is a complete webinar. It's about 50 minutes long, so it's a bit long, but it's jam-packed with information that you need to create and discover the fraud, expose the fraud, and discover specific ways that you can use that information to permanently stop the sale and compel your lender and your servicer to come forth and be honest about who actually owns the note. And if they can't prove that they own the note, then they have no standing or no right to foreclose on you. So I hope you join me in the webinar. There's a link down below for you to register for the webinar right now. I encourage you to do that right now and get started to learn education. You have more options, more power than you realize. The bank is relying on your ignorance to get away with their fraud. So I hope to see you in the webinar. Be sure to click below to register for the webinar, and I'll see you on the other side. Thank you so much. Have a good day.